before court?
Oh, maybe
40?
quite a. Julie will tell you, I thought there were about 18, but it could be more. 22 families.
So just for interest, this family, it's 22 people, is that correct?
22 families.
Families.
So they
with
are.
one.
Yes.
So to take 22 files, would it be that difficult? And look at those files?
Well, no, I don't think so. But where so obviously at the commission that will happen. So at the commission, the families again, quite correctly, will say, can we look at not just your file you have currently, but the history of our files, going all the way back. That's what we want to look at, and we want to, having investigated that and asked people questions about that, we then want to ask the commission or the fact finder or the court ultimately to make findings of fact against somebody in government, and therefore government, on the ground that he or she interfered with the prosecution in the case of a family member.
I'm just thinking the manner in which the other cases were resolved was because there was someone looked at a file, is that correct?
Yes, my lady. Someone looked at a file, and as Mr. McAdam will tell you, people didn't look at files for years. And that's the problem. Very little happened. It's a little bit like waiting for Godot. Nothing happened. In this case, for a very long time. So, just one last point I want to make. In the SCA case, in Rodriguez, what the SCA finds, so I've shown my lady what Colopin J finds. In the SCA case, the Dwaba J, who wrote the majority judgment, he finds what he finds at paragraph 26, and that is so this, my lady, was uploaded after all the authorities were uploaded. This was not part of the original bundle. I'm not sure what number it is in
No,
the
you might be.
authorities bundle. 26, the Dwaba J says, it was during this 14-year period that the executive adopted a policy position conceded by the state parties. The TRC cases would not be prosecuted. Again, just a very broad, sweeping conclusion. It is perplexing and inexplicable why such a stance was taken, both in the light of the work and report of the TRC, advocating a bold prosecutions policy, etc., etc. Then, he goes on to say, at paragraph 30, the ineluctable conclusion in all the circumstances is that political decisions were taken by the executive which may have affected the investigation and prosecution of TRC cases. That's as far as the Dwaba AJ, I beg your pardon, the SCA was prepared to take it. There were decisions that may have affected the investigation and prosecution. It didn't say that they did affect them. And then, Kachalia J.A., who wrote the minority judgment, he said this. Paragraph 52 of the judgment.
Yes, I do have it, thank you.
He says, apart from the delay and the consequent prejudice to the appellant that may have resulted therefrom, the other grounds relied on by the appellant to support the stay are either speculative or amenable to being ameliorated through less drastic remedies. The first is the accusation of political interference that resulted in the initial decision not to prosecute apartheid-era crimes, including the present case, and contributed to the delay. The NPA disclosed this interference, but insisted there was no trial-related prejudice. Allied to this ground is the contention that the prosecution is being pursued for an improper purpose, which overlaps with the case of political interference being made. The court rejected both contentions. Its conclusions cannot be faulted. And what happened? So what happened? In fact, what they're saying is, listen, in what Rodriguez said was he relied on political interference for his application to stay permanently the prosecution. And what Collip and Jay found, and what the SCA says is, well, that's really neither here nor there. There may have been, but we're dealing here with a delay. And for the purposes of your delay, well, in fact, the NPA say, yes, there was a delay, but there was no trial prejudice. And the court, the SCA says, well, when it comes to a delay, that is really not, that's not a key component of our decision in deciding whether delay should result in permanent stay. It doesn't feature in our decision. It applied the rules, the common law rules applicable to the stay of prosecutions, and it said you don't comply with those. So my lady, even insofar as there is reliance on Rodriguez, and again we say that in Rodriguez what featured there was primarily what the applicants call, the families in this case call, direct interference. They refer to it in the affidavit under heading direct interference, and that is the interference related to the Chikane case. As we say, well, that's not going anywhere because that's been resolved. Unless there's anything else, my lady, those are submissions.
No, I will hear you in reply. Mr. Chaskelson. Are you comfortable there, Mr. Chaskelson?
Comfortable enough. Never comfortable in court. My lady, our learned friend has presented an argument that has a superficial common sense appeal. The basic proposition, if we understand it correctly, is that the President has appointed a commission of inquiry that will look at the same subject matter as this litigation. It will have tools to investigate the matters more deeply than this court. It will investigate thoroughly, and so our learned friend says common sense dictates that this court should not consider the applicant's application until the Commission has reported and made its recommendations. But with respect, my lady, on common sense, on closer inspection, this appeal to common sense breaks down. And it does so for three fundamental reasons. The first is a simple issue of fact. The applicants are seeking justice and recompense for crimes that were committed between 30 and 55 years ago. That's the period we're dealing with. The perpetrators of these crimes have either already died or are dying off at a rapid rate. If you committed a crime 55 years ago as an adult, by definition, you are at least 75 today. You're not going to be around much longer to face criminal prosecution. The applicants themselves are getting older and older. Many of their family members have already passed away, family members who were driving this process themselves. They don't have time to wait indefinitely for a commission of inquiry to report and for relief to be recommended and for the President to debate whether that relief should be implemented or not, and for all sorts of steps to take place thereafter, which may or may not provide them with that to which they are entitled. And the one thing to which they are entitled is their day in court. And after decades of waiting, we're not talking about months or years, we're talking about decades. They are entitled to that day in court while they are still alive. That really should be the beginning and end of the stay. But the problem of delay is compounded by the nature of Commission of Inquiry proceedings that the respondents invoke as a reason for the stay. Recent South African history shows that commissions of this nature tend to drag on and on and on. It is an extraordinarily optimistic proposition to put forward the idea that this commission will be able to do a thorough job on its investigation and report in 4 months' time, which is all that it has left of the original 6 months. Even if it could, commissions are not institutions which can ever make final determinations. At best, they can make recommendations which the President may or may not choose to implement. This President has already changed his mind dramatically about whether to oppose the litigation or not. He first said he wasn't going to oppose, then he changed his mind. The administrations that preceded him are alleged to have been actively involved in the suppression of the investigations and prosecutions that the applicants complain about. The SCA has already found that there was political interference, or that there was a very real possibility of political interference.
Just a moment. As long as you do not interfere, I'm trying to follow.
In this context, my lady, the applicants are entitled to be a little skeptical as to how, when, and even whether the President would implement any recommendations that may emerge from this Commission of Inquiry in their interests. And even if the President were to adopt those recommendations, there's an entirely separate debate about whether it would be competent for the President simply to disburse public funds on the basis of a recommendation of a Commission of Inquiry. Our understanding of the legal position is that absent an order of court or an act of Parliament which would authorize payments of the sort that the applicants are seeking, the President can't just dip into the National Revenue Fund and start handing it out to people who he thinks are worthy beneficiaries.
So for that purpose, the applicants will need to come back to court.
Indeed, indeed. At the end of a commission to say, at best, well, now we've had the commission, there's been a recommendation of payment of constitutional damages. The President apparently accepts this. We now want you to order this as appropriate relief for violation of constitutional rights. But like a review application, this is not something that can be granted on an unopposed basis where I stand up as counsel for the applicants and say the papers are in order, my lord and lady.
Now that would be more in the line of a settlement.
But even the settlement of this nature, a court would have to be satisfied was a legally competent settlement. And for that to happen, the court would have to investigate whether, in the light of the facts that are on the papers before it, constitutional damages was appropriate relief in this case.
Well, the recent SCA judgment seems to differ, that once parties have settled a matter, the court may not interfere and go behind that.
But, my lady, that is the general principle. But I mean, it goes to the nature of the jurisdiction over appropriate relief for constitutional violation. Is that a matter that parties can privately settle between themselves? Is it a matter that a court has to apply its mind to?
It's not a normal civil.
We're not saying that this is a cut and dried case, and certainly if there was a settlement, we'd be trying to persuade the court. The settlement's in order, your lady shouldn't grant the settlement. But there is a debate there, and for present purposes, one has to assume that it is at least a possibility that just like a court cannot review and set aside an administrative act by agreement, it has to inquire into the grounds for the setting aside. The same principle would apply to the exercise of its remedial jurisdiction under Section 38 of the Constitution.
No, I hear you. It's a somewhat different remedy. It's not a civil matter with two private parties.
Well, it is private parties, but the remedy, but it's not a simple remedy in relation to a common law statutory right where the answer is foretold if the right is established. On any scenario, my lady, the passage of time between the establishment of a commission and any ultimate action to address the applicant's needs is likely to be lengthy and one fraught with many uncertainties. And the applicants can't be expected to put their case on hold in the hope that the Commission will finalize its proceedings speedily. All of these uncertainties will be resolved. They will obtain what is due to them as a result of the state's fundamental betrayal of its constitutional obligation to prosecute the perpetrators of apartheid murders. And all of this will happen while they are still alive. And that is essentially what the President is asking in this case. There's one last submission that we make, my lady, which is that the request for a stay is constitutionally offensive because it is a violation of the fundamental right of access to court. If we strip away this veneer of common sense, what's actually taking place is the following. The President is a respondent in pending criminal proceedings over a justiciable dispute. He doesn't want to take a politically awkward decision, we just heard that. For political reasons, he doesn't want to choose where he stands in this dispute. So he doesn't want this dispute to go ahead and be resolved in court as quickly as possible, and why he doesn't want it is because it's politically awkward for him. So wearing his hat as President, not as respondent, he has created a body to advise him on the very issues which form the subject matter of the pending proceedings. And he's done that months after the proceedings were instituted. He's rejected attempts to mediate the dispute. This advisory body that he set up will have no power to bind him. Best it can make recommendations which he can reject or accept as he sees fit. Even if he accepts those recommendations, they'll have to be implemented. He can choose how they're going to be implemented. And in this context, he is asking the courts, your ladyship in particular, not to entertain the justiciable dispute that the applicants have brought before the court. He says, wait until my advisory body has told me how I should respond to this dispute. Then you can look at this justiciable dispute. But that's a fundamental violation of the applicant's constitutional right of access to court. That right is a right to have a justiciable dispute with the President determined by a court. And it's trite that justice delayed is justice denied. But that trite proposition has particular power in this case, because we're talking about applicants who include elderly family members of victims who were murdered between 35 and 55 years ago, and who don't know how much longer they have time on this earth.
So this is with the delay that we've dealt with, yes.
So delay here acquires a particular power and importance. People have a right to have this case determined while they are still alive. And if the case is delayed indefinitely, and in the process some of the applicants pass away, then that's a fundamental denial of justice. And it's not your ordinary case where a delay of 6 months, a delay of a year is essentially neither here nor there. This is a particularly critical delay situation, and in due course I'll take your ladyship to the papers just to illustrate that proposition, because when one looks at the individual affidavits of the applicants, one sees how many of the family members have already died, passed away through old age or illnesses associated with age, how old the applicants themselves are, and how there is a very real risk that if this matter is not resolved soon, if the hearing does not take place, at least on the ordinary basis, and one would hope on an accelerated basis, the people who want this justiciable dispute determined may not be here to see whatever the result
No,
is.
I do have that point.
Now, if a private litigant came to court saying, let's put this litigation on hold, I want a year or so to give my advisors an opportunity to consider the subject matter of the dispute and to advise me so I know where I stand. Well, you'd laugh that private litigant out of court. It's a preposterous suggestion coming from a private litigant. Now, the fact that it's the President who's advancing this proposition makes it worse, not better, because the President has constitutional obligations in relation to the fundamental right of access to the court. The President's constitutional duty is to promote, protect, and respect that right. A private litigant has no such obligation. The President's there to give effect to the right of the court.
The Commission of Inquiry part and parcel of executive functions. Must be if
the appointment of a commission of inquiry.
Yes, and the work that the Commission do, because the recommendations will be presented to the President.
Indeed, it is. But one has to separate the function of the Commission and the function of the Court.
That's where I'm getting to.
Indeed.
Because the Court function totally separate, independent.
Indeed.
From the executive. So it's the three arms of government, and the judiciary should not interfere, and the executive should not interfere in the judicial process.
Absolutely. And I mean, there are fundamental differences between a court and a commission of inquiry. A court is there to decide disputes between parties. That is the primary judicial function. And a court, particularly in civil proceedings, does so in a matter which is not proactive. It looks at the evidence before it, and it decides on the basis of the evidence before it, not on the basis of any other evidence, whether rights have been established and what remedies should flow if they have been established. Then it makes orders. If it has established that a right has been violated and there is an appropriate remedy, and once it makes an order, the party in whose favor that order is made has the ability to execute that order, to engage the machinery of the court to have it executed. A commission is a completely different animal altogether. First of all, it sits within the executive. It's there to advise the executive, the head of the executive. It can't determine any rights.
It does have the benefit of being able to call witnesses and for witnesses to be cross-examined. So it is a very useful tool, if I can call it that. But that's separate from the judicial system.
Indeed, it's completely separate from the judicial function. That only illustrates that. But your ladyship sitting in civil proceedings can't say, well, to get to the bottom of this, we really need to hear from X. So I'm going to subpoena X because I want to get to the truth. I don't want to decide the dispute on the evidence before me. I need to find the truth outside the evidence before me. So I'm going to subpoena this witness. I'm going to call for the production of those documents. That can't happen in the civil process. And what is happening in this stay application is two things are happening. First, the President is seeking to avoid having to make a politically awkward decision and is asking the court to spare him from making a politically awkward decision. That's a fundamental, it's fundamentally incompatible with the independence of the judiciary. The courts are not here to spare the President from making politically awkward decisions. That's really not the court's function. That is a violation of judicial independence to make that request. But in support of that request, the President is conflating the function of a court, which is to decide a dispute on the basis of the evidence that is brought before it, with the function of a commission, which is proactively to try to get to the bottom of everything, exercising inquisitorial powers, and attempting to get to the truth.
Well, having discussed these issues, maybe one should just go one step back. What is the test for a stay? It must be in the interest of justice.
Well, it must be in the interest of justice, but if one looks at the precedents, once
convenient.
No. It's more than convenience. A stay of proceedings is slightly different from a postponement, because a stay is linked to something else. It's a stay pending finalization of another process. And if one looks at the authorities, and we've done that in the heads, it starts at page 27 of the hard copy heads. It's 005 to 11. The test is interest of justice. I'll come back to that test later. But the categories that have crystallized are fairly limited. There is one category where there are parallel civil and criminal proceedings. And certainly the old law was always, in those circumstances, you didn't want the criminal accused to be prejudiced by having to go on oath in the civil proceedings until the criminal proceedings had been finalized. So you would stay the civil proceedings pending finalization of the criminal proceedings. But these are both proceedings by courts of law. And even that principle seems to have been eroded substantially under the Constitution. There are a range of judgments which say the right to silence doesn't mean that you can choose when and how you want to litigate your civil proceedings when there's a pending criminal proceeding. But let's treat that as one specific category where stays were recognized. There was another category recognized historically that where a litigant had failed to satisfy a costs order in related proceedings, well then the proceedings that that litigant wanted to institute against the same party would be stayed pending finalization of the cost order. That's again a very specific category. Now outside those specific categories, when one looks at the case law in relation to stays, one sees there is a principle that if there are judicial or arbitration proceedings that will set up a res judicata or an issue estoppel on the matter before the court, and if it's more convenient for those proceedings to be determined first, then one would stay these proceedings pending finalization of those proceedings.
But res judicata, that's only in judicial
proceedings, indeed. When one gets out of the courts and one goes to administrative bodies that are part of the executive, there are cases where a statute that gives an organ of state the power to make certain determinations specifically vests the courts with a discretionary power to stay civil proceedings that may be determined by the administrative determination. And we've given some examples in paragraphs 43 and 40, footnotes 43 and 44 in paragraph 63.2. There are cases in copyright law that we've come across where there isn't a specific statutory power to stay, but the courts have nevertheless assumed that there is a power to stay pending a decision, or I call them intellectual property because they're not just copyright, pending a decision by the relevant functionary who will determine whether that intellectual property right exists, either by confirming a patent or granting a deviation from that, but do that administratively, and that determination will be a final binding determination in administrative terms. It will be binding, and because it will be binding, it will then determine the outcome of the parallel civil proceedings.
Yes, that makes sense.
And those examples we've addressed in paragraph 45.
That's somewhat different than what we have here, because it is in binding.
It absolutely, milady, and that is the crucial issue, that we cannot find a single case where court proceedings have been stayed pending the finalization of other proceedings which will not be binding. The only purpose of staying court proceedings in this sort of context is if the subject matter of the litigation is going to be determined in another form, determined, not pronounced upon in a recommendation, but actually determined, then a court has a discretion to stay. And what's significant, milady, is that in the cases that we've seen where the court doesn't have an express power to stay pending the parallel administrative process that will determine the issue. We have seen courts assume a power to stay. We haven't seen courts actually staying. They've assumed a power, they've investigated, and they have emphasized that that power if it exists, has to be exercised extremely sparingly, and on the facts of their individual cases, they haven't exercised. But, so if one steps back and looks at the field of stays, one sees stays are clearly recognized where there are parallel legal proceedings or arbitral proceedings which will set up a res judicata that will determine the same issue.
Or would have a binding effect.
Which would have a binding effect. They are clearly recognized where a statute which sets up an administrative decision-making power that can determine the dispute before the court expressly vests the court with the power to stay if it's convenient to do so. And finally, there appears to be recognition that even if there isn't an express power conferred by statute, if the statutory determination will be dispositive, will determine
That's
the
the
dispute.
inherent power that the court has to
Indeed.
its own procedures.
Indeed. But in that context, the courts have always emphasized that that is a power. The power of stay in those circumstances has to be exercised.
Yes.
And the footnotes in that regard, the leading and most recent case in that regard is cited at paragraph 45 of our heads. It's the Clipsal Australia case at paragraphs 18 and 19. It's an SCA judgment from 2010. What one sees nowhere is a power of stay being assumed, still less exercised, to allow a parallel process to take place within the executive, which will not determine the dispute, it will at best result in a recommendation to the executive responding.
Well, advice.
Advice.
What it boils down to.
Indeed. Who may or may not accept that finding. I'm going to go briefly to the papers just to emphasize the criticality of delay in this case. But before I do so, I just want to get past this red herring that has been raised in the papers, on the heads, and indeed in my learned friends' submissions, which is essentially an argument that, well, the applicants have made up no case. They're bound to lose. And your ladyship, with respect, put your ladyship's finger on that, the flaw in that argument, which is the applicants are dominus litis. If they, wrongly advised by myself and others, believe that they have a case that is arguable, but in fact they don't, well then they will lose.
Yes.
That is how
It
it
could
works.
never be that a respondent say, stay the case, because applicant, you do not have a good enough case.
Indeed. I want to emphasize that we, this legal team and the applicants are confident in the merits of their case. But I don't want to take your ladyship to chapter and verse in this regard. It's frankly not the respondent's choice. Respondent thinks that we have no case, well then, let it stand up in court and say, you have no case. Dismiss, your application must be dismissed. That's how the resolution of justiciable disputes takes place. Party to a dispute can't say, well, actually, for political reasons, I don't want you to lose your case, so I'm saying don't run your case now, because then you will lose it. And I don't want to be the party. I don't want to be seen to be winning this case. That's not the business. Well, a court should not give much credit to that sort of argument. Milady, if I can briefly go to the papers, I do want to spend some time here, even though the proposition is with respect self-evident, but I'd like to illustrate it with examples from the papers.
Mr. Chaskelson, I notice it's almost tea time, And if you are now moving to directing the court to facts, would this be a convenient?
It would be.
Thank you. Court adjourns until 3:30.